All right. We are exactly on time. That in itself is a miracle. So as part of this symposium, we solicited papers from authors around the country to get their take on different aspects of cyber enforcement. And some of the authors are here today, and they're going to give what we call flash presentations of the main idea of their paper. And these flash presentations are essentially the 5-minute elevator pitch of what they're talking about. And because we have a very, very full agenda, I'm really going to make an effort to keep things moving. And we just saw recently how well I was able to get Senator Mark Warner to leave the stage. So if they go over 5 minutes, you'll see that ability again. But to get us going, I'd like to welcome to the stage Todd Huntley. He is the managing editor of the Journal of National Security Law and Policy and the director of the National Security Law Program at the Georgetown University Law Center. And Todd is going to introduce this special issue of the Journal of the National Security Law and Policy Journal that was co-produced with Third Way on some of these ideas. And then following Todd, our first author speaking today will be Shemin Keitner and Garrett Hink. And Shemin is the Alfred and Hannah Fromm Professor of International Law at UC Hastings College of the Law, and she will be speaking on cyber crime and cyber war. And Garrett is a research assistant at the Carnegie Endowment for International Peace, and will talk about his paper co-authored with Tim Maurer on indicting nation-state actors. So welcome to the stage, our next participants.
Thank you, Joe. Good morning. On behalf of Professor Bill Banks, the senior editor of the Journal for National Security Law and Policy, and the rest of our board of editors, I'd like to thank Mieke and the rest of the staff at Third Way for putting together this wonderful edition of the journal. She really did do a great job of reaching out and bringing together a group of distinguished experts to publish their research and recommendations on these complex and important issues in this future journal of the edition of the Journal for National Security Law and Policy. The journal began in 2003 as a publication out of the Syracuse Institute for Security Policy and Law, formerly known as the Institute for National Security and Counterterrorism. They just changed their name in the last couple of weeks. And they did that with the assistance of the American Bar Association Standing Committee on Law and National Security. In 2012, the journal moved to Georgetown and is now a joint publication between Syracuse and Georgetown Law. It's the world's only peer-reviewed journal devoted exclusively to security law and policy. Our articles that we publish address the issues across the entire spectrum of challenging and emerging national security issues: counterterrorism, use of force, law of armed conflict, intelligence, and of course, cybersecurity issues. And these articles are meant to take a look at both legal and policy approaches to hopefully presenting solutions to these challenging issues. As you can imagine, and as represented in this special edition, we are increasingly seeing more and more submissions on cybersecurity issues. However, we have never before had such a comprehensive edition looking at cybersecurity and cybercrime issues from the perspectives that we have in the upcoming journal. The journal will be out, this edition of the journal will be out sometime in spring, hopefully no later than March. You will hear from several of the authors today. Just one final word on the journal. Our board includes, and we seek submissions from, members of academia, practitioners from both government and public sector, or private sector, and we also publish student notes. So if you have that great article that's just ready to be published, please submit it. You can come to our website, jnslp.com, and we have guidelines as well as the email for submitting your articles. And we thank you again, Mieke, and we look forward to receiving your submissions. Thank you. And with that, Professor?
Actually, I can just hold this, it's easier. Got my 5-minute timer, there we go. So I'm Shemin Keitner, it's a delight to be here. I'm here to talk about the paper that Mika Oyang and I are co-authoring for this special edition of the journal. It's called Cybercrime versus Cyber War, Paradigms for Addressing Malicious Cyber Activity. Like everyone in this room, we're worried about a common problem. Too often, cybercrime does pay. Mika and I started thinking about this project on the margins of this year's RSA conference. As you know, Mika has extensive experience in the legislative branch, and I've spent some time in the executive branch. We compared reading lists and noticed that almost all the recent books about cyber have the word war in the title. Some of this presumably is marketing, but we thought there was something deeper going on as well. Our paper looks at the implications of viewing malicious cyber activity primarily through what we call an armed conflict model or frame, rather than a law enforcement model or frame. Now, this clash of paradigms is nothing new. We all lived through the war on drugs, and we still seem to be fighting the war on terror. And some threats, including those in cyberspace, do require hybrid responses, especially when they emanate from nation states or non-state armed groups. But the emphasis on cyber war has, in our view, come at the expense of sufficient attention to an epidemic of cybercrime. One result of an armed conflict approach to transnational cyber threats has been to leave domestic law enforcement officers inadequately trained, inadequately resourced, and inadequately supported to identify, deter, and punish offenders. Our article is a plea to keep the essentially criminal nature of most malicious cyber activity in focus, even as we grapple with the implications of malicious cyber activity that is conducted, sponsored, encouraged, or tacitly permitted by nation states. If the goal is to protect people in the United States from harm to our persons, property, and ability to conduct our daily lives, then we need to work harder to impose consequences on those who use the internet to commit crimes currently with impunity. Domestically, this means focusing additional resources and training on detecting, preventing, and punishing forms of cybercriminality, such as internet-enabled fraud, theft, and exploitation. Internationally, this means increasing diplomatic efforts to secure cooperation from nation states that currently permit or even tacitly encourage cybercriminality. Now, to be sure, simply adopting a law enforcement paradigm is not a panacea. Cybercriminality almost invariably involves actions, whether human or machine, across multiple territorial jurisdictions and potentially implicates multiple different domestic legal systems. You just heard Ben Wittes call this the elephant in the room, the problem of jurisdiction. Even under a law enforcement model, the degree of international cooperation required to apprehend and punish cybercriminals has to date proved to be a major obstacle to creating effective deterrence, even when the authors of malicious cyber activity can be identified and their involvement proved beyond a reasonable doubt. Moreover, the potential involvement of nation-state actors means that the foreign policy consequences of law enforcement decisions need to be assessed on a regular basis. In certain circumstances, and with respect to certain actors, an armed conflict model might be more appropriate, but it should not be the default for addressing malicious cyber activity. The need for flexibility and coordination requires an institutional structure that can oversee, direct, and deconflict enforcement initiatives, something that, despite the post-9/11 advances that we heard about this morning, does not currently appear to exist with respect to cyber enforcement. At their core, the laws governing the use of force developed to constrain the behavior of nation-states. An armed conflict model thus understandably focuses on the cost-benefit analysis for nation-states of engaging in or permitting malicious cyber activity at or near the armed conflict or armed attack threshold. As we heard this morning, this involves thorny problems of defining what conduct is and is not permitted in cyberspace, an ongoing project for international lawyers. But in the meantime, we can use a law enforcement model to focus on enforcing the laws that already exist, both in jurisdictions from which cybercrime emanates, based on the location of the conduct, and the jurisdictions in which cybercrime causes harmful effects, most notably harmful effects in the United States. By increasing penalties for individuals who violate domestic criminal prohibitions on cybercrime, we hope that our paper will help to prompt reflection on how best to think, talk, and act about this pernicious problem. Thank you.
5.5 years ago, the U.S. Department of Justice announced the indictment of 5 officers in the Chinese People's Liberation Army. This marked a sea change in how the United States approached enforcing international cybercrime when linked to state actors. It was also the first of many to come, a series of 24 indictments and other criminal charges against individuals in 5 separate nation-states linked to their governments: China, Russia, Syria, North Korea, and Iran. This indictment marked a shift because previously many thought that the United States was either unwilling or unable to attribute hacking when linked to a foreign government. My co-author Tamara and I became interested in this question, and particularly in what the effect of the indictments that have come out since 2014 has been. Our article presents an analysis of the 24 cases, which by our estimation includes 195 criminal counts against 93 foreign nationals linked to foreign state governments. We argue that criminal charges have become an important part of U.S. foreign policy when it comes to combating state-linked cybercrime. However, the use of criminal charges as a foreign policy instrument raises complex challenges and should only be thought of as one tool in the broad toolbox of national security instruments for addressing this problem. As we heard in the discussion this morning with the senator and congressman, indictments can't do everything, and we agree. I'll briefly detail their utility as a foreign policy instrument, potential downsides, and outline our approach, which we term persistent enforcement. The common conception of, and in fact objection to the use of indictments as a foreign policy instrument has been that they do not lead to arrests, and ultimately that they do not lead the associated state actors to refrain or stop the malicious behavior. We think that this is a too narrow conception of their foreign policy utility and ignores many valuable purposes that they can have, which include: 1, indictments are a valuable means of attributing foreign activity. It's worth remembering the depth of the attribution problem just 5 years ago and how indictments have brought us to the point where we can all now say that the U.S. government has a powerful capability to do this when it comes to state actors. 2nd, indictments are a valuable tool of disrupting foreign hacking activity, arresting those responsible, disrupting relationships between proxies and their governments, and further, potentially changing groups, forcing groups to change their tactics to adapt after they've been publicly outed. 3rd, charges are a valuable instrument of naming and shaming. The PLA indictment is a valuable example of that, and it helped lead the 2015 Obama-Xi agreement. 4th, charges are a valuable instrument of cooperating with allies to jointly attribute malicious activity. We saw this happen at least a couple times last year, and we expect to see it more in the future. This clearly demonstrates that indictments have broad utility as a foreign policy tool, yet using law enforcement in this specific way raises some complex challenges. One of them being that the U.S. Justice Department maintains a high degree of independence, especially when it comes to the decision to prosecute certain cases. This independence from other agencies in the U.S. government can limit its flexibility and impact in foreign policy terms when a decision to bring a case, and particularly when to unseal it at, per se, for instance, a politically insensitive time. 2nd, while the United States has cooperated with allied governments in prosecuting these cases, no allied government has independently brought a case against a foreign state-linked hacker on its own. We think that it's important that other countries follow the U.S. example, and it's worth looking into why they have not thus far. Lastly, with the number of indictments that have become unsealed, it has become clear that their broad utility is not in wholesale deterring foreign actors from stopping hacking targets in the United States, but rather in disrupting specific activities, strategies, and tactics. Our recommendation is that U.S. law enforcement develop a tailored strategy for using indictments against particular countries and particular groups where they are most effective and can have the most impact. We term this persistent enforcement and detail it further in the article, which I would urge you all to read when it becomes published. Thank you.